The topic of today's video is legalese, or what the hell are attorneys ever even talking about? The first term is pro se. Pro se just means that you are representing yourself, which just means you don't have an attorney. Injunction comes from the word enjoin. It stops, it prohibits, it prevents, it pauses, it enjoins something from proceeding as planned. An injunction for protection is the Florida legal term for a restraining order. There are a bunch of different types. I will make a separate video about that one day. But an injunction for protection prohibits, enjoins, stops, prevents a respondent, the person the restraining order was filed against, from contacting the person who filed the restraining order, also called the petitioner. Pleadings, some people think, are just everything filed in court. That's not technically correct. There are certain types of filings that are considered pleadings. The petition initiates the case, it starts everything. The petitioner files a petition to start the case. The petition is basically the same thing as what's called a civil complaint in civil cases. It is a document that the petitioner signs under penalty of perjury, basically takes an oath that everything in it is true. It contains all the allegations of why they're asking for what they're asking for, and then all the specifics of what they're asking for. And that gets served on the respondent. So you file a petition to start the case. The respondent can then file an answer. That's another pleading. The answer is where the respondent will either admit, deny, or state they have no knowledge of the allegations in the petition. The petition should be numbered. It should include numbered paragraphs, and the answer will say, paragraph 1, admit. Paragraph 2, deny. Paragraph 3, no knowledge. When the respondent files an answer, they can also file a counter petition. A counter petition is going to look pretty much the same as a petition, except it is called a counter petition because it is filed by the respondent, not the petitioner. It is filed after the petition has been filed and served. The respondent files an answer, and if they want to make their own allegations and make their own requests, they file a counter petition. If the respondent files a counter petition, the petitioner can file a reply or an answer to the counter petition, where they do the same thing that the respondent's answer would do: admit, deny, no knowledge. Motion. A motion is a request that is not a pleading, but it is something that is filed once the case is open, usually, and throughout the case. You're asking the judge to make preliminary determinations about issues before you get to a trial or to a final hearing or to the final determination by the judge or potentially an agreement. There are a lot of different types of motions. I can probably do a whole separate video on motions. I just wanted to distinguish them from pleadings. The pleadings are the petition, the answer, counter petition, and reply. Motions are basically requests that are being filed by one party or the other, or jointly if everyone's in agreement, throughout the life of the case. Supplemental petitions. A supplemental petition is something that you file after the case has been opened, decided, and closed, and you want to reopen it and make a change. In a divorce, for example, you have a supplemental petition for modification. You have a supplemental petition to permit relocation with minor children. These are all things that you would file after the case has been concluded and closed, and you need to reopen it and you need to ask for something else. Dissolution comes from the term dissolve. It is to, I think we know what the word dissolution means, but a dissolution of marriage, for example, in Florida, dissolves the bonds of marriage. It is a divorce. It's a fancy term for a divorce. A dissolution of a business dissolves the business. Default. A default means that you have had a particular amount of time to respond. You missed that time, you failed to respond within your allotted time frame, and now the court has entered a default, or the clerk has entered a default against you, which allows the other party to proceed with the case as if you have responded that you consent with everything. You have been defaulted, you lost your right to present your own defense. There's a lot of legalese and legal terms of art and general just fancy words that have very specific meanings in the law, and this video is already getting pretty long, so comment below and let me know what other words you'd like me to define or what other concepts you want me to make a video about.